Hello everyone, this is Maan Chaudhary. So today I want to address some questions on my YouTube channel, on my company's YouTube channel, Fast Track Consultancy. The video is viewed by a lot of people, and they have left some comments, and some comments are really interesting, and I'm sure it will help a lot of people. So the first question is that the skilled worker visa is valid for 5 years. If I change job and employer, do I need to pay again? How long would that validity for a new? Well, if you are changing your employer altogether, so you have to get a new certificate of sponsorship, and that, yes, you have to make a new application of updating your employer, and yes, that will involve a cost of application fees and stuff, and the relevant documentations. For example, if you are on a shortage occupation and you're switching to a shortage occupation, then obviously you have to pay the relevant fee. But if you are changing to the if the new employer is not in the shortage occupation, then you have to pay the relevant fee, which is a bit higher. Also, you have to pay the IHS and everything as well. So yes, you have to pay your for the new application. So the second question is that I came in UK in June 2023. They asked me to shift the city, and now after 3 months they have asking me to change my city. So I don't have enough money. Well, this is the thing, that you have to choose your employers wisely, like any job. So for example, if even if you're not immigrant or migrating to UK, any person who is joining a company, they should know what companies stand for, what are their standards are, what are other employees are working for them are feeling, what are their reviews. You check a lot of things before you choosing employer. So in this case, you have chosen an employer who is not very I would say a good employer, and they are making you work in different cities. So I'm afraid you are kind of stuck with them. There is no law against the employer that they have to put you in certain place or certain city. If you chose them, they will kind of make you work wherever they want. However, if they are being unreasonable, you can always switch to a new employer, get a new certificate of sponsorship, and you can always switch the employer altogether. If they are doing it only to you, that's another case of discrimination. For example, you can always complain to employment tribunals. So you can sort out certain things, as but end of the day, that won't help your case anyways. You are kind of bound with that certain employer, and you have to spend long time with them in order to attain your permanent residency. So I would say that bear with them for time being. If they get you adjusted in one of the city, but if they don't, then obviously you have no choice but to leave that employer. Yes, you can. If your employer is not giving you enough hours, you are welcome to work part times to other care homes or other relevant jobs. But if you want to switch your employer altogether, then you have to get a new certificate of sponsorship, and you need to apply for that, updating your update to your visa. And then, yes, and that will incur a cost, of course. Exactly the same thing. If your company is not giving you work, it means that that company did not have work in the first place. So which means that that employer was not good enough to hire people. So for yourself, on one side, you can complain about your employer to the employment tribunal or to the home office, but for yourself, you have to find a new employer and switch your employer to find work. Otherwise, you do have no choice but to leave the country. So yeah, it all comes down to the choice you have made before you took their employment and you travel all the way to UK. I was a student in UK. I dropped my studies in the middle of the course. I applied for Tier 2. I got the working visa, but last year. But now I want to change employer. But can I in the new rules, you cannot switch visa if you have. So I would say that the laws usually does not work retrospectively. So the new laws will not implement from the past. So new law would be implemented only going forward. So since you have switched from student visa to a skilled worker visa already last year, before the changes happened, you will not be applied to the new rules. You can switch your employer, and there will not be a problem. Yes, yes, you can switch employer to the entire different category as well if you get a certificate of sponsorship, and you pay obviously different amount of fees to the home office. For example, if you were a carer, so your fees for application fees for the carer was less than the employments which are different, or which are not in the shortage occupation list. So you have to, and then shortage occupation list carers, they usually don't pay much of IHS as well, immigration health surcharge, whereas other employments they do have to pay the so you have to pay the relevant fees. And yes, you can switch your employers even though it's out of the category. I hope that helps. Thank you.